Good afternoon, everybody. Thank you for attending this. This is our GDPR webinar. It's the first of what we believe to be a series of webinars. Over the next 30 minutes or so, we're going to put 30 minutes of a bit of chat and a bit of slideware with 15 minutes questions from the floor, from the people that are on the bridge. So the agenda, what is GDPR? We'll be looking at that. How it will affect educational establishments, and that's going to be important. And we'll move on to discussing practical tips and assistance which educational establishments can take to prepare for these changes. And what we're going to go through here is a high-level view of the GDPR, and RM as your trusted IT partner. We see it as our position to be able to give you this high-level overview and to provide some guidance. So we'll be exploring how we can help, what we have in our kit bag to assist you, before quickly reviewing some suggested next steps for education. Okay, so the General Data Protection Regulation, abbreviated horribly to GDPR. So this slide, as a preamble, this is a summary infographic from the Information Commissioner's Office, or the ICO, and I'll be referring to the ICO. The ICO, the Information Commissioner's Office, have produced this infographic, and this infographic is it's a pretty good summary of the GDPR. Now, the Data Protection Act of 1998, otherwise abbreviated horribly to DPA, was created as a national response to the Data Protection Directive, and that came out of the European Union. Accordingly, all EU member states have slightly different statutes for protecting individuals with regard to the processing of personal data. That was the Data Protection Act. Now, the GDPR, conversely, is a regulation, and this means that it has direct effect across all EU member states. So there'll be no nuances in individual states. Now, with Brexit that happened last year, obviously there are some issues around that, but GDPR is absolutely happening in the UK, although that there are some wider European implications. And the GDPR replaces the Data Protection Act on the 25th of May 2018. Now, this area of law is detailed and quite complex, and RM is not able to adequately review the entire directive in one webinar. And as I said earlier, this is a series of webinars. Therefore, we're going to focus on personal data and retention in this session. So this infographic is the 12 steps to the GDPR summary. It comes from the ICO. There'll be a link to get to this graphic later if you haven't seen it already. The GDPR, we said, it kicks it in 25th of May 2018. That date will not change. That's a fixed date. And if any of you are around in the late 90s, if you remember the millennium bug that everyone was talking about, how there was a drop-dead date of January the 1st, 2000, where systems had to be ready. Simple as that. They had to be millennium compliant, as we called it 18 years ago. This is a similar kind of thing in that by the 25th of May 2018, your systems must be compliant and your processes must be compliant with these regulations. So we said we're going to focus on personal data and retention for this session, and this infographic is a nice summary from the ICO. We've got a link to it later, summarising the 12 steps that organisations should be taking to be compliant for May 2018. And the summary is designed to fit all enterprises. It's not really focused on education. Now, we're expecting an update from the ICO clarifying what GDPR means for education. And so we could watch this space, or more accurately watch their space on their website. So going on to the next slide here, how will the GDPR affect educational establishments? And I'm going to jump around in some of the blocks here, and we're going to talk about those in a little bit more detail. So as discussed, we are focusing on retention of personal data in the webinar, and there are many changes which may affect educational establishments, and additional advice should be sought where required. Now, if you look at the bottom left-hand corner, we're going to be talking about the higher penalties, and some of those are really big numbers. So we're going to start with that. Let's start with the money. And then we're going to be talking about the breach reporting requirements up there in the top right. There's a couple of other areas on how the ICO defines personal data, and we'll talk about the definition of personal data in the top left. And for additional governance and assigning of a data protection officer, or DPO, and the extended rights of the individual, we're going to leave that for a future webinar. Okay, so the higher penalties. Let's start with the money. Show me the money, as Tom Cruise once said. The ICO can fine up to the greater of 20 million euro, or 4% of the global turnover. Now that's a lot of money, right? Under the DPA, non-compliance could see fines of up to £500,000 imposed by the ICO, but from May of next year, when the GDPR kicks in, non-compliance 20 million or 4% of the global turnover, whichever is the greater. Now, the amount of the penalty will depend on the circumstances of the case, and there's a sliding scale. The ICO will decide how they apportion this. That's a big difference. And if you look at the breach reporting requirements, the statistics that we've had given back to us is that over 85% of online fraud and data breaches are not reported. And what the ICO has tried to do is they've tried to haul this in order to make sure that it's more transparent, and they can track the number of breaches. So it's very important to give any possible data breaches due consideration. Now, even if the ICO disagrees with your actions, the fact you have thought about it and documented the same should be held in your favour. Failure to notify a breach when required can result in fines of 10 million euro or 2% of the global turnover. And if you're aware of a data breach, you've got 72 hours in which to report it. Now, that's not a lot. If a data breach should occur over a bank holiday weekend, you really don't have, and you discover it, you really don't have that much time to react. 72 hours is pretty quick. So let's have a look at the how we're extending the definition of personal data. The definition of personal data is pretty much unchanged from the Data Protection Act. The Data Protection Act is listed on the left there. However, online identifiers fall within the definition. So, for instance, there are many different types of cookies that will become personal data because they contain personal identifiable data. Educational establishments may wish to review their policies, such as a privacy policy, might cover bring your own device, for instance, to ensure that these are up to date with respect to personal data. There are 6 principles of the GDPR that relate to personal data. And this, I'm aware, is a very wordy slide. I'm not a big fan of putting a lot of words on slides, but there's no way we could avoid it, this one. So heads down, I'll see you at the end. Article 5 of the GDPR requires that personal data shall be processed lawfully, fairly, and transparently for the specified explicit and legitimate purposes, adequate, relevant, and limited to what is necessary, accurate and kept up to date, held for no longer than is necessary, and processed in a manner that ensures appropriate security. And when you guys get the slides to this, there's a lot more notes in the slide here that goes into the background of that. There's way too much text here, but what they're saying here, the gist of what they're saying here is that the controller shall be responsible, and the controller in this case is you, it's the schools, by the way, The controller shall be responsible for and be able to demonstrate compliance with these principles, those 6 points above. So as a result, organizations should look at their data and assess whether their policies are for storing data adheres to these points. What we recognize is that probably what most schools are doing is storing everything forever. You've probably got some kind of dusty foothill in a basement somewhere, full of bits of paper tied up with string, and that's unmanageable. We recognize that. But if you look at those 6 points on this slide, you can see how your dusty foothills are in breach of those 6 points. And this is where we need to start looking at what data we store and how we manage it. We're going to go into a little bit more detail in that in a moment. Data minimalization is the key here, and a data mapping exercise may be very useful. So, what can educational establishments do to prepare for the GDPR? Well, as we said, a data mapping exercise. Consider for what or which purposes is data a personal data processed. Census requirements. Some of that is statutory. Contacting suppliers, managing employees, for instance. Whose personal data is held? The pupils' data. And how long do we hold it for? There are guidelines around retention. And it's not all straightforward. It's not all up until the date of birth plus 25 years. Some of that you have to store for longer, and some of it for shorter. Employees, parents, candidates, suppliers. Authorization slips for school trips where there's been an incident. You need to assess what type of data is collected. Your personnel files, the names, the addresses, and how you pick it up directly from the individual, and do you have consent? It's important that you know what's held and what you're processing it for, and how it should be treated. And part of this is understanding about the use of personal data by third-party data processors. So a data mapping exercise will enable educational establishments to identify the personal data held and where it is stored, be it off-site, paper copies, as is pretty much mostly the case, I think, with most schools, in the cloud if you're moving to an archiving product such as Integris. On hard drives, the list is endless. How do you know what data is on your hard drive? Does it contain personal data? How would you find that out? That should come out of your data mapping exercise. So examples of when data is held, which may include personal data, information about the governors, the management, the pupils. So I'm not going to go down that list, you can read those. This is a non-exhaustive list, but it should be used to begin thinking about what sort of data is held by educational establishments. We know that governors will hold personal data, minutes, agendas, reports. There's retention issues around that. Pupils, probably the largest area, hopefully the largest area for educational establishments, with data held in attendance registers, pupil record cards, pupil files, correspondence, any applicable reviews on special needs or circumstances, examination records, pupils' work, etc. Now, I'm not going to go through all of those. So you've got a lot of data kicking around. Let's look at the security of that data. Now, the controller, don't forget, the controller is you, must implement appropriate technical and organizational security measures to protect personal data against accidental or unlawful destruction or loss, alteration, unauthorized disclosure or access. And this harks back to that breach we were talking about earlier on and the 72 hours you have to report a breach. Depending on the nature of the processing, the measures may include encryption of the personal data, ongoing reviews of security measures, redundancy and backup facilities. We have a number of solutions for backup and regular security testing. So once you've determined what the personal data is, where it's held, the next step is to ensure that it is GDPR compliant. Now, the idea that data controllers should ensure the security of the personal data they process is a core concept under the Data Protection Act. But the GDPR has the same requirements, albeit slightly more prescriptive. Now, where RM is your managed service provider, we can assist with these requirements. And the systems, the security measures that RM uses are fully compliant with the Data Protection Act and with the GDPR. Now, I mentioned about retention, and this one's a thorny subject. So let's have a look at the three areas of retention of data. A data retention policy. Data retention policies are needed to comply with DPA and the GDPR. The general principle is that personal data should be kept no longer than is necessary. Can you guarantee that those tied up bundles of paper in a basement in your school are kept for no longer than is necessary? And this is one of the drivers to going paperless. Once a data retention policy is drafted, it's important that the educational establishment complies with it. So we could look at implementing consistent record-keeping practices, cost management. We know it's expensive to retain unnecessary records. Those dusty foothills of tied-up bundles of paper going back however long, probably forever, they're not manageable. And in order to be legally compliant, you need to be able to manage the disposal, the deletion of those records. What should it include? Well, some exploration of the data held must be done to identify suitable time periods. There's no central government produced guidance for recommended retention periods for all potential data. The considerations are government meeting agendas may only be applicable for the meeting itself and can be destroyed on creation of the minutes. Minutes of senior management meetings may only need to be kept for 6 years.
Yeah, you want to do them on them all, or just one or two? Or...
Examination results may need only be kept for 6 years, with unclaimed certificates being returned to the appropriate examination board. Pupil records may have statutory requirements under various Education and Disability Acts, with retention periods ranging anything from 1 year to 12 years up to 35 years. How are you going to manage that? And moving along to deletion. After the retention period has been reached, it's very important that the data is deleted in accordance with the data retention policy. This may mean the physical destruction of records, some of which may have been held off-site for many years. It will take time for an educational establishment to be compliant regarding historical records. However, RM can definitely help you with your current records. Okay, how can we help? Well, RM Integris can help you here. We can securely upload and store documents against pupils and staff, keeping information in one place and easily retrievable. We can have an archive service that retains data for as long as you need, held securely and accessible whenever required. We can record and report on consents gathered from pupils and parents, and reports to help gather in and regularly check information stored. And of course, we have cloud backup solutions that will back up the archive for as long as you need the backup. Don't confuse the terms archive of data and backup of data. They're very different, as one of my colleagues pointed out to me earlier on last week. Okay, where can you get advice? Well, some good sources. The ICO website. Now, the link that I put in the slides here, that's a live link going over to the ICO website. That's where we got that infographic that I showed you on the second slide. ICO also has a free helpline. Free is always nice, we like free. They're manned by experts who will answer any query that you have. The ICO has guidance notes on the deletion of personal data. And it's a good source for any questions you have about GDPR. Okay, Apologies for some of the technical issues. Well, some of our colleagues were going to have a little powwow and find out what happened there, but that's our GDPR webinar, session number 1.